Counterpoint. I'm your host, Christine Argentine. As you know, this is the video cast where we talk about consumer issues affecting trends related to class actions or different types of litigation. We are here in California, in Los Angeles now, at our partnership retreat, which means I get the pleasure of sitting down with one of my partners, Ken Wilton. I'll let him introduce himself.
Likewise, thank you. And I am Ken Wilton. I'm here in Los Angeles. I co-chair our advertising and marketing group.
Great. And today we're talking about deceptive fees,
Right.
Particularly with respect to the federal guidelines as well as some California law that is in place. So, Ken, why don't you tell us a little bit? Let's start with the federal guidelines.
Yeah, we'll start with the FTC guidelines. They became effective on May 12, 2025, so they're just starting the enforcement of them. As they were being developed, let's back up, a little background for this. The reason we're even talking about deceptive fees is because over the last couple of years, we've seen, many years, a trend of having these hidden fees, where probably the best example is you buy tickets to the Taylor Swift concert, you find a price you like, you find 2 tickets, you go to the next screen and suddenly there's a 30% fee on top of that, and the next screen there's a shipping and handling fee. And this kind of pricing, you've now invested time in trying to find the tickets, and now they're going to cost you twice as much as you thought the face value was.
Yeah. And all the laws that we're seeing right in the consumer space, all about transparency, all about making sure the consumers are well aware of what they're getting, when they're getting it, how they're getting it. And that's kind of aligned with what these are meant to do.
Exactly. And so what the FTC started to do was to try to figure out how to regulate that, or at least provide guidance on it. And the original proposals would govern virtually everything. By the time the guidance got enacted, though, it was limited to live events and short-term rentals.
Okay.
So, which gave a sigh of relief to most industries, because more broadly it could affect everything that we'll talk about in a little bit about California. But for the FTC purposes, it's really just the live events and the short-term rentals. And what it requires is a disclosure, the transparency that you were talking about. It requires that the consumer know up front when they're booking the room or buying the ticket that this is going to be the series of fees that they're going to be paid.
And when we say upfront, we're talking about how soon in that transaction do they have to see those fees?
They should see them, and we're talking about online transactions.
Right.
And it should be on the screen where they are deciding on the purchase of the ticket or the booking of the room. There are a couple of exceptions. Taxes can be excluded, and certain mandatory government fees can be excluded. But when it comes to the actual ticket price and upcharge for the fee for the platform, all that needs to be disclosed up front.
Okay, so you now know the full price you're paying when you hit pay.
When you hit pay.
Okay.
Or when you go to the pay screen.
Sure.
I mean, it's not when you hit pay, because that's what we were doing before. It's when you're actually making the purchase decision, you have it right in front of you. Because then, if anybody's purchased anything online, then you have to put your name, credit card, all these other things.
Yeah.
But the point is to be transparent up front, so I'm paying this, now I have to give the information to buy it.
Yeah. Okay. So what kind of enforcement do we see with the FTC guidelines?
Well, the FTC guidelines, like I said, became effective 3 months ago, so we haven't seen much yet.
Okay.
And FTC investigations take some time
Sure.
To wind themselves out. However, California, where we're lucky to be sitting right now, we have a statute that became effective last July, 2024, and that also deals with deceptive fees, but is much broader in terms of the scope of the kinds of companies that need to address them.
Okay.
And the penalties are greater, because it's part of our Consumer Legal Remedies Act, which has a $2,500 per event or per violation fee. There's attorney's fees, etc. So the consequence of that is you find the plaintiff's bar.
Right. And you have a right of action within the CLRA that allows consumers or plaintiff's firms or whoever's bringing that action to bring it straight to court.
Correct. And over the last year, we've seen at least a dozen or so, both lawsuits, class action lawsuits, but also investigations by our AG's office. Our Attorney General office is also doing investigations into certain companies.
Okay, so what kind of fees now? Is it the same type of fees that are being governed by the California statute, or is that broader as well?
It's the same type of fees in the sense of any fee that is not taxes or certain government mandated fees would fall under the rubric of it needs to be transparent up front.
Okay.
By way of example, if you have, I'll say, a cleaning service where you can rent, or any other the gig economy things out there, if there's a fee that will be charged perhaps by the company, that needs to be disclosed up front or wrapped into it.
Okay.
It can't be disclosed 2-3 pages down the purchase process.
Sure.
So that's really what the concern is from the statute perspective. From the compliance perspective, it's in some ways easy to comply, but it takes the conscious effort to say, okay, I'm going to redesign how I present these fees. Mm-hmm. And that's, unfortunately not everybody's aware of the statute, not everybody's aware of the fact they need to change their practices. And so that's why we're seeing these class actions that are being filed saying, well, on page 1 you have this fee, on page 2 you have 4 other fees.
Yeah. So you talked about it being broader in terms of applying more broadly throughout the industry, not just live events and short-term rentals. Who needs to comply with this?
For example, if you're renting cars or parking, at our local airport here, LAX, there are outfits that will actually allow you to reserve parking. Mm-hmm. And those companies should be disclosing whatever extra fees may be involved, whatever it may be. Covered parking, things like that, just up front so that it would cover those. And I mentioned cleaning services. There's a number of gig sort of things where you can, there's companies that allow you to hire someone to move furniture for you. And usually it's an individual who will charge some $25 an hour, I'm just making it up. And then the company will charge another $10 an hour for insurance or whatever and the fee for the company. Those need to be disclosed at the beginning. So in other words, if I wanted to hire somebody to move my dog bed for everything else, and it's $25 an hour, I need to know that the company itself is going to charge an extra $10 when I hire Steve to move my dog bed. Okay.
And so when we're talking about online reservations, right? Car rentals, hotel rentals, all of that's going to be included.
Covered. All of that's covered.
Okay.
What I haven't seen yet, which may be interesting, if you have food delivery, you use one of the various apps that are meant for that. Some of them just show an increased price for the food. Some of them have a delivery fee. Mm-hmm. Delivery fee would need to be disclosed up front.
Right.
What I've seen more recently is that the $10 meal at the restaurant is now $12, $13 online. And really, that's because they're just wrapping the fee into it, which is a simple way of doing it.
And so, could the California statute cover that? Is it broad? Is the language broad enough to cover something like that?
I don't think so.
Okay.
Because the fee itself is now part of the structure.
Okay.
So it's not. The point is that the consumer hasn't made a decision based on one fee, and then as they go through the purchase process, they're suddenly hit with 5 other fees.
Right.
That have nothing, like, the classic example in the hotel space is a resort fee, which we see all the time.
Sure.
It's like, it's $100 a night for a room and park, and then, self-parking is another $15, and the resort fee is $30, and suddenly at the end of the day, you're spending $200 a night.
Sure.
And that's really where all this started, and that's where we're seeing some of the class actions.
So how did the FTC guidelines fit with the California? Are they going to preempt? Or are they going to apply simultaneously?
They technically preempt because they're federal law, and the guidelines actually say that they preempt. However, because especially in California, the California statute pretty much covers exactly the same thing for live events and short-term rentals, I don't see that the preemption is going to matter too much. And the preemption itself is couched in terms of if they're materially different.
Okay.
So they're playing hand in glove, from the consumer perspective. So in that respect, you're not going to see, no, sorry, you can't enforce the California statute because there's an FTC guideline out there.
And you said we're seeing a lot of class actions kind of arise out of this, AG investigations. Is there mitigation that companies can be doing to avoid, obviously strictly following the guidelines would be one way.
That's actually the best way.
Right.
The best way is, and we've seen this with some of our clients, where they've proactively, which is the only way you can do it, proactively said, okay, there's a new statute in town. let's change how we display our pricing. And so if you put everything up front, there's no problem. But the problem is not everybody's aware of it.
Right.
So this is one of those, like anything else in the world, ignorance of the law is no excuse, so you kind of have to be aware of it. But we have seen many of our clients that would just change the architecture of their website, which fortunately is not that hard. It just takes a conscious effort, getting the developer to change how the pricing works so that at the end of the day, everything is transparent and upfront.
Right. And obviously, as we see a lot of consumer litigation in California. Have we seen this expand to other places?
Interesting you say that. In your neck of the woods, in Illinois, good old Cook County, there recently was a lawsuit filed involving a parking reservation company in California.
Okay.
And that California-based company used the same scheme pricing disclosure in a number of different states, including Illinois. And so that case, intriguingly, seems to be predicated on the idea that an Illinois resident who is reserving parking at like O'Hare, for example, can rely on the California statute that didn't for the non-disclosure.
Oh,
I'm not sure that's going to fly, but this is something you've dealt with, I think, in the interstate.
Yeah, it typically comes down to, unless the statute expressly says, right, this can apply to, outside of the state, it typically comes down to where the injury occurs, right? And so in that instance, it seems like the injury would be occurring in Illinois, although I suppose if it's an online reservation and you made that reservation in California,
or you contacted California to make that reservation because that's where
registered in their systems. Yeah, it's an interesting question for sure. And I think, the California statutes are often very broad. There's often a lot of damages that are allowable under those statutes with, as you said, attorney's fees. And so they're really attractive statutes to file claims under. Yeah. So I think it's not surprising that we're seeing litigation expanding outside, trying to use those statutes.
No, and I think we may see more of that until we get the court decisions that start to narrow down the scope of the statute or the reach of the statute, which is what we've seen in most of the consumer class actions. It usually takes a little bit of time. The statutes pass, suits are filed, and then the courts start deciding what are the limitations of the scope of the actions that might be subject to the statute.
Right. Yeah, we talked about that a couple weeks ago on this video cast, right, in terms of the tracking technologies using the wiretap statutes to, say that there is a wiretap on different websites. And the courts are really grappling with how is this a wiretap, right? How far does that extend? Mm-hmm. While very much keeping in mind that it's about transparency, it's about privacy of data, and so I think there is a balance there for sure. I mean, certainly these pricing statutes are good practices to have, but when you get into the class action litigations, it can get very expensive very quickly for companies that are operating in that space. Yeah,
this is a clear situation of the ounce of prevention is a very good idea.
Yeah. Because
unlike maybe some, the compliance is not, I don't view the compliance as that difficult if someone puts their mind to it.
Right.
And it's just a question of doing that.
Yeah. Well, that's great. I think, obviously there's lots of different statutes out there affecting consumer issues, so we're going to be touching on a lot of those over our season. But thank you, Ken, for joining me.
That's, my pleasure.
Really nice to get other colleagues involved and talk about these types of issues.
Thank you very much. Thanks for having me.